Since 2021, adults in Virginia have had the legal right to grow cannabis at home. But what does the law actually allow, and where does it draw the line? Misunderstanding these limits can turn a legal personal garden into a source of serious legal trouble. In this video, we provide a clear, authoritative breakdown of Virginia's home cultivation statutes, so you understand exactly what is permitted, what is prohibited, and how to stay compliant. Here's the context. It's essential to understand the legal framework that allows this. Home cultivation was enacted under the Virginia Cannabis Control Act. This law created a legal distinction between personal use and illegal distribution. The legislature's intent was to allow adults to cultivate a personal supply, not to create unregulated commercial grows. This distinction is the foundation for all the rules we're about to discuss. It's also critical to remember that while state law permits this, federal law still prohibits cannabis cultivation. This video focuses solely on compliance with Virginia state law. Here's the legal explanation. Let's break down the specific provisions. The law states that any person 21 years of age or older may cultivate up to 4 cannabis plants for personal use at their place of residence. There are several key conditions attached to this right. First, the place of residence means your primary dwelling. You cannot legally grow these plants at a secondary property, a vacant lot, or a separate storage unit that is not your home. Second, the limit of 4 plants is per household or residence, not per adult. So, if 4 adults live in one house, the total legal plant count remains 4, not 16. Third, the plants must be kept from public view. This typically means indoors or in a secured, opaque enclosure outdoors. They must also be tagged with your name, driver's license or ID number, and a note that the plant is being grown for personal use. Finally, you may possess the cannabis produced by these 4 plants, but that harvested cannabis must be stored in your residence as well. Who it affects? These laws primarily affect Virginia residents who choose to exercise this right. However, the implications extend further. For renters, your lease agreement may prohibit cultivation regardless of state law. Always check your rental contract and consult with your landlord. For homeowners, consider how cultivation might affect your homeowner's insurance policy. Local governments also have a role. While they cannot ban home cultivation outright, they can use zoning and ordinance powers to regulate certain aspects, such as requiring specific setbacks for outdoor enclosures. It's prudent to check with your local commissioner of the Revenue or Planning Office. Neighbors are also affected. Ensuring your plants are not visible or detectable by odor is not just a legal courtesy but a practical way to maintain good community relations and avoid complaints. Why it matters and what to watch next. Understanding these limits matters because crossing them changes the legal category of your activity. Exceeding the plant count, growing in a non-residential location, or failing to tag plants can lead to charges beyond simple possession, potentially including manufacturing or intent to distribute, which carry severe penalties. This legal framework is also foundational for the future. As Virginia moves toward a regulated adult-use retail market, the rules for personal cultivation may be reviewed and adjusted. Staying informed on these potential changes is crucial for continued compliance. For a deeper analysis of the legal text, related court cases, and local Norfolk ordinances, we have published a detailed article on our website. Let's look at this scenario: zoning versus lease agreements. A renter in Norfolk has reviewed Virginia state law and understands they are permitted to grow up to 4 plants. Their apartment balcony receives excellent sunlight and is not visible to the public, seemingly meeting the legal requirements. However, their standard lease agreement contains a clause that prohibits the growth of any plants on the premises not approved by the landlord and bans any activity that could increase insurance liability. This creates a direct conflict. State law provides a right, but a private lease contract may prohibit its exercise. In this situation, the lease agreement is likely to govern. Landlords retain significant authority over property use, and violating a lease can result in eviction proceedings, regardless of the activity's state legal status. Here's a question for you. Where do you believe the balance should lie between a tenant's right to engage in a state legal activity? And a property owner's right to restrict activities on their property? Do the rules change for a homeowner versus a renter? Put it in the comments. We encourage you to share your perspective on this and other compliance questions in the comments below. For a deeper community discussion on local Norfolk ordinances and landlord-tenant law, you can join the Norfolk City Cannabis Community Forum. If this legal analysis was helpful, please like this video. To stay informed on Virginia cannabis laws and regulations, subscribe for more authoritative educational content.